You've brought a lawsuit seeking compensation for the harms and losses you suffered because of somebody else's carelessness. And now, during the course of your litigation, you are examined by a defense doctor. Did you know that the defense doctor cannot introduce his report into evidence during the course of your trial? Would you like to learn why? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law in the state of New York. Today I'm coming to you from beautiful, sunny Sanibel Island, Florida, and I have a few minutes to share this great information with you. So now, the defense has an opportunity to actually examine you to see what the true extent of your injuries are. And they're going to call this an independent medical examination. Well, you should know that there is nothing independent about this medical exam. The defense hires a doctor who frequently will do physical examinations for the defense and the insurance company, and now the doctor who does an examination of you is required to generate a report. And that's done for one key purpose, to let the attorney who now has asked the doctor to do a physical examination on you, to let him know exactly what it was that the doctor found. And importantly, the defense lawyer has to take that report and send it to us, the plaintiff's attorney, so that we now know what the defense has looked at, what conditions they think you have, and what problems you still have. And now we have an opportunity to use that report during the course of trial to cross-examine that particular witness. But what if, for example, that doctor is unable to come into trial? Can the defense lawyer take that doctor's report and now admit it into evidence so the jury can then read it? The answer is no. You want to know why? Because that information would be considered hearsay. So what's hearsay? It's something that's written or something that's said now that's being introduced into evidence, and we don't have an opportunity to cross-examine the person who actually wrote that. So why is that important? It's important because information that's considered hearsay cannot come into evidence. For example, if there was something in the report that was extremely damaging, where it said that the patient was lying, or he felt that the patient was exaggerating, if the doctor has not come into court to testify, there is absolutely no way the defense attorney will be able to take that report, admit it into evidence as a substitute method to now get that information in front of the jury. He's going to have to get the doctor into court in order to talk about his examination. So why do I share this great information with you? I share it with you just to give you an insight and an understanding to what goes on in the litigation process that you may not be familiar with. You know, I realize you're contemplating bringing a case involving medical malpractice or even an accident case or maybe even a wrongful death matter in New York, and you have legal questions. Well, if you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.